I'm Diana Shepherd, the editorial director of Family Lawyer Magazine and Divorce Magazine. Joining me today is family lawyer Brian McNamara, who's here to discuss child support in Texas. If you're a Texas parent going through a child support dispute, you should keep watching. In the next few minutes, Brian is going to answer some of the most frequently asked questions parents have about Texas child support laws. Thank you, Brian, for taking the time to speak with us today.
Thanks very much for inviting me.
What are the factors determining child support in Texas?
Yeah, that's a good question. On its face, it's very simple. We just look at the payer's income and we do a percentage. However, it can get complicated. Um, Once we know what the income number is, it's relatively simple to calculate child support. We take the gross annual income, subtract the required Social Security withholding for one person claiming one dependent. We subtract any union dues, any state income tax if it's paid in another state, and then we take a percentage of the remaining number if it is $9,200 or less. Child support calculation only applies to the first $9,200 per month of net monthly income. That equates to about $145,000 a year, depending whether someone's employed or self-employed. For one child, it's 20%. So that would be $1,840 is the cap for one child. It goes up in 5% increments. So for two, 25% would be $2,300 a month. Where it stops being simple is in calculating the income number. If someone has had a simple job, not a simple job, a salaried job for the last several years, and it's the same amount every year, it's a pretty simple calculation. If someone gets bonuses, commissions, overtime, any other extra income, it gets a lot more complicated because we're really trying to project future income to calculate child support based on what the income will be in the future, and that can be a little difficult, and that's where litigation arises. That's where the arguments happen. But once we settle on what the number is, then the guidelines apply. A judge has discretion to deviate from the guidelines if the proven needs of the child require it, but that is not common.
I just saw that one of the mothers of Eddie Murphy's children just went back to court to have her child support raised from $25,000 a month to $35,000 a month for the reasonable expenses. So if you have a celebrity or a sports figure or something like that, is it possible in Texas that they might get those astronomical sums?
Theoretically, it's possible, but it's probably never going to happen. A judge can exceed the guidelines, like I said, based on the proven needs of the child. So if you have a child that has special needs, a special needs child that has expenses and the resources are there for the payer to pay it, a judge can certainly exceed the guidelines. If you have a child with serious other medical issues, for example, that may require a lot of treatment and the resources are there, the judge may exceed the guidelines. A child could be a genuine sports prodigy option for the Olympics. I mean, every parent wants to think their kid can go through the Olympics, right? But if it's a genuine, this kid really has great promise and they need a lot of lessons. We're paying for coaches because they're training all the time. We're doing a private tutor. And if the parents' resources are there, a judge could exceed the guidelines. But I don't see how that could ever get to 25 or 35,000 a month. It's based on the needs, the proven needs of the child, not the parents' needs. And so that can lead to unfair outcomes where a payer who has a very high income could be paying less than 10%, 5% of their income in child support because it caps out at $9,200 of net monthly income, which is not the same as taxable income. And then on the other end of the spectrum, a lot of people complain that the child support doesn't even cover daycare, because it's only 10%, 20% for one, or 25% for two children, and it doesn't even cover the kids' daycare. But no, I don't see it ever getting that high in our state, absent some really, really unusual circumstances that I can't think of right now.
Is child support paid directly from one parent to the other?
Oh, no, that's a good question. A lot of people misunderstand that. No. Texas law requires it must go through the state disbursement unit. It's a central registry. It's run out of San Antonio. The federal government, I don't know, sometime in the last 20 years, I guess, required states to have a single central place to pay the child support when it's withheld, um, so that the employers know where to send it. They take the money from the paycheck. If it's a Texas employee, it all goes to this place in San Antonio. So there's, instead of hundreds of places, there's 50, one in each state. However, our law says it must be paid through the state disbursement unit in San Antonio. It can either get there by wage withholding, or the payer, can pay it directly. Any payment outside of the state disbursement unit is considered a gift. A judge has discretion to give credit for it, but may not. And they require a very high level of payment. So it is really unfortunate when you see a payer in court saying, I gave the other parent numerous checks, but I can't find them, or my bank has been sold and bought and they don't have the records. And the other parent says, yeah, the person gave me some money, probably maybe $1,500. And the other one saying, no, it was at least $10,000. The judge is probably going to give him credit for the $1,500 that the parent acknowledged. And other than that, they still owe all that child support and they still go to jail for it. So it is very important that it be paid through the state disbursement unit, where they keep an official record.
What are the basic expenses that child support is meant to cover?
Anything. And what I mean by that is uh, there's no review, there's no audit of the parent receiving the child support. They can use it for whatever they wish. Um, and so if the children are being neglected, the other parent can seek primary conservatorship, which many people would call custody. And sometimes that does happen, where the payer of child support says, the money's being wasted. The other parent, the kids are not being well taken care of. They keep coming to me for money for sneakers and money for jeans and money for school supplies. Meantime, the other parent is dressing lavishly, and I know they're using my child support on outrageously expensive clothes or vacations or something. In that case, the option is to seek primary conservatorship. The parent can't go to court, and the judge isn't going to order somebody isn't going to audit them or check their books to see how they're spending the money. However, child support is supposed to cover all of the children's expenses, and that can put the payer in a difficult situation if the recipient payee says, look, kids, we're poor. I can't buy you the shoes you need for school. Get them from your other parent. And then they go to the other parent and say, I need new shoes. And that parent says, well, I just paid, $2,000 in child support. That's tough on them to say, sorry, kids, you can't have your new shoes because the other parent says you're poor. But yeah, they're supposed to cover all of that. And typically they do. What I described isn't that common, but it does happen.
When does child support end in Texas? Are there any circumstances under which it can continue until the child has finished college?
It ends whenever the later of the child turning 18 or graduating high school. So if they graduate high school at 17, it will continue to be paid until their 18th birthday. If they turn 18 in high school, it will continue to be paid until they graduate. The judge has no authority in our state to order payment of child support after that. But because the judge has discretion on the proven needs of the child, it's unclear if they could order someone to contribute to a college fund while the child's under 18. When I've seen those, they've been done by agreement. Off the top of my head, I'm not aware of a case where it's been tested at the Court of Appeals whether the trial court could order a parent to pay guideline support plus an additional sum into a college fund until the child support stops. But maybe. But other than that, no, it stops at 18. There's no provision to say you must pay, continue to pay through college. People used to voluntarily agree to do that. It would be enforceable as a contract, but not anymore because college costs skyrocketed. Some people got really burned on that.
We all know that the one constant in life is change, particularly over the last 2 years. We've become really aware of that.
Right.
Can child support or conservatorship agreement be changed in Texas after it's been court ordered? If so, what are the circumstances under which it could be changed?
Yeah, yeah, they can. So obviously, life changes, like you said, and so a court can change an order. To do that, you have to first show that there's been a material and substantial change in the life of the child, or I should say, the circumstances of the child or one of the parents that necessitates or requires the change. So, the change in circumstances must be from when the last order was signed or the last mediated settlement agreement was signed, whichever was first. Um, so, a parent can't just say, I don't like the deal I made, or I don't like a decision the other parent made, so therefore I want to change custody. Unless, of course, that decision has created a material and substantial change in the circumstances. So, for example, a parent who decides, I'm going to pull the kids out of school, I'm going to homeschool them. That would probably qualify as a material and substantial change in the circumstances of the children that would allow a court to look at modifying that. Some recent case law in the last couple of years says that I'm sorry, it's been affirmed in the last few years, it goes back a ways, that the relief granted, whatever the trial court changes, must be related to the material and substantial change. So you can't come to court and say that both parents have remarried, so that's a material and substantial change in their circumstances, so we want to change custody, unless you can show that that remarriage somehow relates to a need to change primary conservatorship. And then you just get into once if you show material substantial change, the usual other factors of that are relevant to primary conservatorship that we talked about a few minutes ago.
For my last question, I realize that this might be a little bit like asking how long is a ball of string, but how much does a custody case cost, and what factors affect the cost? Realizing there'll be a range, maybe you could give us, sort of the least someone could expect to pay and close to the top end.
So yeah, no, so here's the difficulty with that. Um, I I do not like that we are the only way to bill fairly is by time. I know it's very uncomfortable for people to not know what it's going to cost, but we literally do not know what's going to be required and what's going to happen. So trying to do it any other way than based on the time spent on the case would be like asking a contractor to build you a house before you have the plans. Say, build me that. Tell me the amount, not to build the house. I'm sorry, to tell you the cost of the house. So tell me what this house will cost, then I'll show you the plans. And by the way, periodically during construction, someone's going to come along in the middle of the night and tear part of it down. We don't know how much, we don't know how often, but it's going to happen. What's it going to cost you to build this construction? Of course, they couldn't do that. It's like that. So it's done on the basis of time. There's two big reasons why custody cases are really expensive types of lawsuits. One is modern. The other one's been around forever. The first, that's the more long-term chronic problem we've always had, is that with most legal cases, you're looking back at an event and you're trying to figure out what happened and what to do about it. So, for example, you're trying to figure out who ran the red light and who caused the crash and were there injuries? Or was there a contract and was it breached and what are the damages? Was a crime committed? If so, who did it? But a custody case, by the time it gets resolved or goes to trial, it could be very different from when we filed it because they're dynamic and they change. So custody gets filed and everybody changes their conduct and they start doing the extracurricular activities and getting involved and going to school, and it all changes. Plus, we have day-to-day issues between the parents where our phone is ringing because somebody didn't turn over the children when they were supposed to, or the children were picked up sick and the other parent refused to turn over the prescription medicine, told them to go to the pharmacy and get their own, or whatever the case may be. So those kinds of day-to-day things and changing circumstances increase the cost. The second, more recent factor is the internet and cell. It used to be that we would say, give us pictures of your kids, and we get, vacation photos in a sleeve like you would get from Walgreens or Eckerd's, when there used to be an Eckerd's, where you just go pick up your photos and say, hey, here's our vacation photos. We had a great time. They say, go take some more of your house, take some of your kids playing in the house and having a good time. Let's show the judge you have a nice clean house. The kids have their bedrooms, they're tidy, and they have a good time playing in the backyard. Now, we get hundreds or thousands of photos because people have cell phones and they're always snapping photos. Plus, there's Facebook and Instagram and all kinds of social media. There's hundreds or even thousands of pages of texts and PDF and all kinds of other data. Even at schools, doctor's offices, they'll ask you questions, they'll check the boxes on the computer. When they print that, it could be 50 pages. If someone had to sit there and write it, it would be 2. If they had to type it, it would be 5 maybe. Now, and people, clients have reasonably, rightfully expect us to know what's in it. We don't want to come out of trial and say, hey, client asked us, why this text from March? Say, oh my God, that was on page 570 of the PDF and we only got up to page 560. Sorry, we missed it. So I have to have a paralegal read them all and highlight what they think is important for the lawyers to look at. They don't decide, but they can narrow out the ones that are clearly irrelevant. Because of that, it greatly has increased the cost of custody cases. As far as the upper limit, I mean, that really depends on what people have resources. You could spend $100,000 on a custody case. You could theoretically, if you made an agreement, resolve one for $5,000 if an agreement was had quickly. Commonly, they can go to $25,000 in our office, but it just depends on the resources and the budget. And unfortunately, but true, like anything else, we try to work within the budget. So there's things we sometimes don't do. Records we don't acquire, witnesses we don't depose, and other matters maybe we don't have a psychological evaluation or an expert, a psychiatric expert, because it's going to cost $5,000 to $10,000 and the budget is simply not there to do it in that case. So that has effect on it. And I go over all this with clients when they come in, and we try to work with them to help them keep these costs down and tell them what they can do to narrow the costs. But ultimately, we have to go through all that material, and that's a big deal. That's a large part of it. So, it is possible. I mean, it depends how contested a custody case is. It's certainly possible to resolve one for $5,000, though if they're not agreeable at the beginning, they're probably not going to agree within that quickly. It's also possible to spend $100 or even more, but those are kind of the range in my office. It's a lot of money.
My guest today has been Brian McNamara, a family lawyer at McNamara Law Office in Kingwood, Texas. Brian is licensed to practice in all Texas courts, including the Supreme Court of Texas. If you are facing a child support or a custody conservatorship dispute in Texas, Brian and his team are ready to help. For more information, please visit www.mcnamaralawyers.com. Thanks very much for your taking the time today, Brian.
No problem. Thank you for inviting me.